Okay, hello everyone and welcome to our webinar, Online Education and Data Protection. My name is Lisa Hofmann. I'm the Chief of Legal Operations at Pridatec and Certified Data Protection Officer. I'm very happy to have Ben Zaretny here with me today. Ben is Data Protection Officer at the DPO Center and a Certified Information Privacy Manager with a strong background in the pharmaceutical, healthcare, and legal sectors. Welcome, Ben.
Thank you very much, Lisa. You nailed my name as well. Well done. Perfectly.
Yes, great. And of course, you can ask us questions anytime during the webinar. You can see it on the right bar down, and we will try to answer everything at the end of the webinar. And of course, if you have questions later on, you also have our contact details. So today we speak about, of course, GDPR and the educational sector. So the European GDPR has created changes in data protection and privacy law across the world. These laws regulate how schools and universities collect, process, store, and transfer personal data. They also require institutions to have in place like some policies and procedures to record and evidence the way that institutions comply with these laws. So within an educational context, schools and universities collect significant amounts of personal data. I mean, we are all aware of that. And sometimes also including special categories of data. And those require additional protection. So in these times, especially with the COVID-19 situation, we noticed a significant shift towards online and remote learning. So basically, schools and universities had no other option than that. And the GDPR should not stop you from delivering this education and also not stop you from keeping students safe. But it does require you to be mindful about how you collect and store personal data from the staff, from the faculty, from students, or even their families. So Ben, due to the COVID-19, the shift to online education happened in kind of a hurry, also in the UK. So how do you see the situation and where do we have to pay special attention?
Yeah, we've, I mean, what we've kind of seen in certainly the DPO Center is the transition from probably a mixed bag across lots of education institutions. Some had really good online remote education provision anyway. Some had really good business continuity if they needed to shift that way. And others, like many other people, have struggled. So they've had to piece it together as they go along. So what we're seeing is a kind of mixed bag, lots of inquiries, lots of questions. It happened pretty quickly, I think everyone would agree. So the things that we're probably going to focus on today is stuff like, I think the key elements that come up, like knowing the risk, making sure that you limit what risks are going to occur over the next, well, let's say 1 or 2 months. We don't know, certainly in the UK, when schools are going to go back, but how we can form some kind of continuity in terms of education provision. So that's kind of what we'll look at. My background, I've worked in lots of education provision organizations, and that's from multi-academy trusts to edtech companies, also worked for education regulatory bodies. So I've seen it from all different angles in terms of what the key considerations are. Hopefully that informs me slightly as to what the key considerations will be from each of those stakeholders, and I'll try and touch on it as we go along in terms of what each one needs to be thinking about.
That's great, and it's great to have you here again because of your expertise, because we received a lot of questions also at Pridatec, especially in the educational sector. So processing all the personal data in the online education, it is important to know which regulations apply. We all know that the Brexit is happening and that some things might change afterwards. But about this topic, we already spoke about with Rob Mason, also from the DPO Center, in detail in a different webinar. So if you're interested in that, please watch this webinar. With Ben today, we want to speak more about an overview of the current situation and the applicable regulations and governance.
Yeah, so every educational organization is going to have its own legislation that it's going to be subject to from the Education Act and other such regulations. The key ones to focus on today, and certainly in terms of using online education providers, would be GDPR, and in the UK, the Data Protection Act 2018. It's got all of the stuff that people should be used to. GDPR is about to turn 2 now, so like most 2-year-olds, it's probably keeping some people awake in terms of whether they're doing it right or not. What we need to think about, we'll touch on the obligation to designate DPOs, but that's a key element, obviously. So most of the organizations we talk with will already have someone in that post. So somebody who we can discuss, maybe support, they're having questions regarding some of the details that have sprung up during this strange time, the pandemic. It's also worth talking about, though, the Article 50 the Treaty of the European Union, in terms of, as of the end of January, the UK withdrew from the EU. A really common question we get is whether we have to worry about the GDPR anymore, to which I say, yes, please do worry politely, but also don't concern yourselves too much. It's just business as usual regarding the GDPR until the end of the transition period, which in the UK is going to be the end of December this year. So that's really important we get that out of the way. And like you rightly said, that's a whole nother webinar in itself. So if people want to go and look at that, that's key for them. For educational institutions, on top of everything else that's going at the moment, if they are not a public authority and can't use the exemption under Article 27 in that respect, they may need to think about appointing a representative in the EU if they're offering services to any of their students, if they're a private organisation offering online, I think it used to call correspondence in my day, but I assume we've moved on now, it's online education. They may need to think about plans regarding appointing or nominating data protection authority. So on top of everything else, that needs to be built into their plan for the remainder of this year.
Okay, great. So for implementing a proper data security concept in the online educational sector in your organization, you should first be able to identify also the personal data you are processing. So what is personal data? This is a really interesting question because a lot of people are not even aware of that. Personal data is any information that relates to an identified or identifiable living individual. So different pieces of information which collected together can lead to the identification of a particular person are also personal data. So personal data that has been de-identified, encrypted, or even pseudonymized can be used, but can be re-identified, is also still considered personal data and falls also within the scope of the GDPR, and this is really important to know. Then, as in the educational sector, we speak a lot about children. Children's data are not automatically considered sensitive data, but they are children are considered especially vulnerable. So therefore, they have, of course, a higher level of protection. But of course, you can have still data of children, which is sensitive data, and it happens, I think, a lot also in the educational sector, just because you have some information we listed here, like racial or ethnic origin, political opinions, genetic data, even biometric data in the schools, and then you also treat, of course, sensitive data. This just as a quick overview about the data you treat within your organization. Then another question for you. So the question,
I think that's really important.
Yeah.
Sorry.
Okay.
I was just saying that last slide there is really important, and it kind of feeds into everything we do. Sometimes schools are very used to, certainly most educational organizations are really used to the standard of data that they're processing. In a pre-pandemic world, we knew what we were doing. We've got our wonderful records of processing activity in place, and we're all very happy about that. I think what we're finding now is, one of the questions we get actually is, all I need to do is ask my students, teachers, etc., to load up this amount of information. Does this count as personal information? I think this is really important, just to focus on the fact that actually it can be very tenuous in terms of how it identifies people, and then suddenly you're caught under the scope of data protection legislation. So it really feeds into everything we'll talk about today, which is right back to the beginning, back to our GDPR training. Think about how simple it is for those legislations to apply, and then start thinking about how you're going to base your risk assessment.
Exactly, because we also have like companies, or I can also think of schools which give numbers to the students or to their personal or whatever, like student number 601, and then they think it's not personal data, not considered personal data because it's not connected to the name of the student, but they have to be aware that it still is.
Absolutely, yeah. It's really common as well when students sign up to apps. It's nice. It's a better way of doing it, but they'll assign them a student number and say use this as your username rather than your actual name. That's great, but it still needs to be included as personal data, and therefore the protections apply.
Absolutely. So the question you have to ask yourself is also if you really need to use the personal data, right, Ben? If it's really necessary for the process.
Absolutely. I think in a rush to keep continuity in education and to do as much of their usual business as usual lesson provision as possible, a lot of schools have looked at how they can provide lessons online through different platforms. There's been some really great ideas. There's been some that are maybe more risky than others. But actually what you need to do is wind it right back and think, do we need to go to those lengths and incur those risks? Could we use some of the existing materials that are already available that don't need to be utilizing a lot or any personal information? So the Department for Education has got a remote education guidance sheets. They've got several now that have all been updated since the coronavirus outbreak. They're incredibly useful. They also list, aside from just guidance, they also list some of their pre-approved vendors, which is great because it shows you how much information you may need to provide if there's registration requirements as such. And they might find either A, that's something that you can add to what you're doing now as an education organization to supplement what you're providing, or also if you're, when we come down to this slide in a minute or two, when you look at the risks and you find you can't minimize them or they are just too high for your own appetite, maybe these are the kind of things you can switch out as a suitable, trade-off effectively. Another thing is the Open National Academy, which has been put together by educational professionals during the outbreak. It's a fantastic resource, actually. It's got lots of interactive tools, resources for teachers, for parents. All of these need minimal or no personal information, and the school can kind of build it into their existing framework. So they might not be as bespoke, and they might not allow that level of interaction with the existing teachers and staff. Again, it's something we'll talk about. But they are brilliant tools and they might reduce the level of risk, at least in the short term. So they're definitely something to think about. And if we sort of down the line, when we talk about what might be considered too high risk, and you say, well, it's either this or nothing, maybe looking at something like this in the alternative, the continued period of lockdown is actually a really nice option.
Okay. Then in the next point, we want to speak a bit about the processing of educational centers on the internet. Schools must inform parents about the use of new educational platforms, technologies, or even apps, as long as they process their personal data. That's correct, right? And how would they do that best? How do they inform the parents?
I think there's two sides of this as well. There's our privacy notification, which is our legal requirement. So we've got to tell people if we're processing their data, ideally using a third-party processor as well, we've got to make sure that we're updating them. Most schools are really good now in terms of their privacy notification. So you can go on there. Schools have got some of the best examples of really good interactive drop downs and such to make it clear. They know that they're processing data on behalf of children. So they've made that, they've removed all the legalese that sometimes we see in industry. So that's super. And that's the minimum standard you need to do, especially if you've started to do something new now, using a different software service. But also if you're going to implement something at this time, I mean, even outside of the pandemic, this is good practice. But if you're going to do it now, especially with the level of anxiety and concern regarding things like cybersecurity, also as an organization, your obligation is to make sure that you maintain security, you maintain integrity in the data protection that you're providing. Make sure you notify people beforehand so they're not concerned it's a phishing scam. That's some of the complaints that we've received. That's some of the stuff I've certainly seen from schools is they've implemented something, they maybe shoved it straight out to the pupils because they've got a direct link to them. And I understand that in a kind of emergency position, you just want to continue teaching as best as possible or use another app to help facilitate teaching remotely. The next slide is really important because we'll talk about taking a step back and reviewing that risk. But whatever happens, make sure all of your, I'll call them stakeholders, which is a horrible industry term, but that does involve your students, your parents, anybody who needs to be involved in the data processing decision making. Make sure they know what you're doing and also why you're doing it. Explain it to them and any educational requirements they might need in terms of using it. It's incredibly important. Do it via the normal channels that you would, but by and large, that's the way that I would approach it.
Okay, thank you very much. Yeah, as you said, speaking about the next slide, what are the risks associated with e-learning? And do I always need to conduct an impact assessment when implementing a new e-learning platform?
So I think this is probably the main question I get asked by any organization at the moment, because things have changed for everybody. I was writing a small article the other day for the DPO Centre about remote working generally, so just what's happened since we've transferred to a full work from home. And as I was writing it, I was kind of, this phrase kept going through my head. I think it's been attributed to Mike Tyson, which is everyone has a plan until they get punched in the mouth. And I think even if you had the best plan possible, if your business continuity and your remote, if remote online provision of education is your absolute meat and potatoes, that's great, but you can't deny that the environment that you provide that has changed of late. There are a lot more people out there trying to hack into that information. The way that you may correspond with individuals is going to have to change slightly for some. So even if you'd sorted that out some time ago and you've invested in a wonderful crystal ball, now's a really good time actually to benchmark against that business continuity, as we'll call it. Is it still working? Have the environmental risks that have occurred created other risks that you need to look at mitigating? For everyone else who's living in the real world, trying to do the best they can at this time, something like a DPIA is the best way to hang the risks that you identify against the mitigations and the minimizations to make sure that you're happy with what you're doing. It might feel like the toothpaste is out of the tube if you've started to push forward with these forms of lesson provision and education provision. But the truth of the matter is, you absolutely need to look at the situation now. We live in a grey area in terms of data protection all the time, but one of the things I can absolutely guarantee people is if you don't want to run an assessment because you're scared of what you might find, you're almost certainly non-compliant straight from the bat. You can't demonstrate accountability by burying your head in the sand. So I think what I would say is, number one, it's a really sensible idea to look at these third parties that you're utilizing for provision of online lessons or education. Number two, if you're doing it from scratch, recently you've implemented it, then that certainly is a new way of processing information, data, personal information, and there is a high likelihood that risks occurred for your data subjects. So the DPIA might actually be legally mandatory as well. So the necessity to do them it might be something you've had running for a long time, and I would recommend reviewing it. If it's something new, then you really need to think about whether this is a legal minimum for you to do.
Exactly. And I know a lot of schools who now kind of also left the teachers a bit alone, and the teachers had to see by themselves what are they using now, using different tools. So then who should help them to conduct the DPIA with their tool? Is it still the obligation of the educational center, right?
Yeah, absolutely. I mean, the school, the MAT, the organization is the data controller, and the individuals that should be looking at this, that you may have a full, depending on how large you might have a fully equipped information governance team, which is great. And some of the larger universities and multi-academy trusts will have them in place, and they are comprised of the DPO, who's there as a mandatory body, and then you'll have your chief of technology. Sometimes that's a service that you've contracted in. Equally, it might be you have an information security individual. You have someone like an equivalent to a CISO who comes in and talks about all of this, and then a compliance officer and all these other things. Or, as you might see with some of it, if I'm talking to someone who's sitting in a small village primary school saying, well, that's brilliant, but I'm the DPO and I have to wear many hats, then unfortunately, it's probably going to fall upon you, which sucks, for want of a better word. There are lots of resources you can draw upon. Doing a DPIA doesn't have to be a wonderful, crazy document that I've seen. Sometimes when you get consultants in, they want to show you how good they can be, and they want to get right down to the very, very, very extreme detail. That's perfect. That's wonderful if you need it. But the ICO template, which is out there and downloadable, actually talks you through the majority of information you need to put in there. It's not a complicated document. What's really good about educational settings is, by and large, they exist already in an environment that runs on risk assessment in some capacity. Safeguarding is going to be a massive part of anyone's provision of education, so they're used to running risk assessments. These aren't that different in any way. The DPO, anyway, mandated by law, is going to need to know the requisite amount of knowledge and have a reasonable amount of experience in compiling everything that needs to be done under the GDPR, which includes data protection impact assessments. So what they need to do is start thinking about what's changed, or what are they putting into the DPIA? How are they providing these this online lesson provision and such, or education provision? So I put a box down there of just things to think about. It's a non-exhaustive list, so there's plenty of things to think about, and most of them are going to be unique to each organisation. But the core ones I see that people ask questions about, first and foremostly, is purpose. What's the scope of the service that's being provided, and is it within the same limits as your remit as an education provider? I'll touch on that a bit in a little while when we talk about non-specific platforms. But think about, is this something we're doing because we have to do it as an education provider? Or is this something we're doing because it's a nice thing to do? Now, that's no different actually from what we see on a day-to-day basis pre-pandemic, where schools and teachers, lecturers would see a fantastic online tool, which looks to all the world to be a brilliant addition to their learning stream, to everything they're doing. This complements all of the lesson plans. It's great, and they sign up and they get the kids to put in their details, and that's wonderful. But actually, is it just a nice to have, or is it actually a necessity? Quite often they tend to be very tenuous in how they're linked. And as I'll talk about later, sometimes at this time especially, they just want a communicating tool. So the children of key workers who are in the schools can talk to some of their classmates, which is obviously good for eliminating anxiety that's forming with the classes on and off school at the moment. But that's probably not within the standard practice of providing education. And therefore that falls into your lawful basis. Think very carefully about what's the lawful basis you're providing this service under. Is it the public interest in provision of education? Arguably sometimes in the private sector in terms of performance of contract, if it's all part of delivering the service. And if it's not falling under provision of education, much like that example I've just given you there, then maybe this is a time when consent is going to be necessary. And if that's the case, what kind of requirements do we need to get a compliant consent in place, and who do we need to get it from? And they're all things that need to be thought of from the organisation's point of view. So before you really do anything, or if you're doing already, thinking about how you're responding and behaving, they're the things that need to go into the DPIA. And then from the point of view of the person or vendor that you're going to engage with, think about important things that you would think all the time with processors. Can data subject rights, can I, by using this processor, still perform my obligations to data subject? So their right to arrays, are we happy that they know exactly what they're doing? Will they assist us with any subject access requests if needed? All of those kind of things. We'll talk about that in a minute. Minimization and limitation. Can you limit the settings on the product, or does it just capture lots and lots of information? We see that quite often with web apps. It's, the cookies are collecting everything and the kids aren't really informed of that. Also, they're asking for loads and loads of information you put in there that ultimately just isn't necessary for performing that particular task. So are you happy with that? And is there a way of adjusting those security settings? When you've got all of those listed down in your DPA, think, well, how can I limit that risk? What can we do from, is there a technical control? This is why again, I'm talking to the guys who've got that wonderful IG team. And maybe if you're there in your primary school somewhere on your own, you should have tech support, be it from the local authority or from a contracted company. This is when you need to lean on them and say, well, what's the situation here? Then on top of that, contractual controls. Have they made assurances to us? Do we have the correct contracts in place with them? Are we compliant in that fashion? It's not too much else you can lean on when you're dealing with third parties than contractual controls, especially at this time when we probably aren't going to invoke our audit rights to go and march around, the Azure data center if we ever had that choice. So we need to look at everything else and working with them, but we'll talk about that a bit more. Once you've done that, are you happy with the risks? It's a risk-based environment at the moment. All bets are off the table because we're all trying to do our best in a very difficult situation. So in light of everything you've discussed and all of the obligations that an education provider is under, including safeguarding, we always have to think about, are we happy with this? Is there an alternative? And then we make a risk-based decision. So it's a long-winded way of saying right back to the start, look at the risks. If you don't know the risks, this slide is probably the most important slide we'll have. If you're going to go off and grab a cup of tea and coffee and a cake, or you're phased in and out, this is the slide to pay attention to, because it really nails everything down. If you don't know what the risks are, it's kind of pointless trying to work out mitigations from now on.
Thank you so much. I think you basically answered already a lot from the next slide. What we wanted to talk about, so what is important when screening potential solutions and lawful basis for use. So better how to conduct a DPIA successfully. And what I do when clients, for example, ask me, can I use this tool? I say at the beginning, no. Then they say like, oh, why we need to use the tool? And I say, yeah, why do you need to use the tool? Then they write me like a justification, and that's already a big part of the process why they use it, because they need to justify it. Normally it needs to have the highest standards also of the EU GDPR, but then of course you can argue with the usability, you can argue of course with the price if you're a small primary school. So those are all the factors you have to look at as well.
Yeah, absolutely. I think one of the things I said to schools over and over again, and it's never more important than now, is as much as you can centralize the contracting process, the engagement process, and certainly centralize the approval process. Historically, and I don't think anyone listening to this, whether they work in a school or they're a DPO for a school or a university or anyone, if they're honest, when they first went in and started to build their records of processing or their third-party supplier list, no one centrally really knew what was going on, because the heads of departments and other groups have gone out and, like I say, they've found things because they have, the user experience is great and the features are fantastic, and that's where it ended. That was the end of the discussion. Sign up, off we go, wonderful. And we retrospectively look at, okay, well, what's the situation here? Do we need to run a risk assessment and look at this? If you can get some kind of centralized process where at least there is, one member, ideally the DPO, who is looking over all of these things. So exactly like you said, and it's a very good tip, and I'm definitely going to steal it, to say to individuals, why do you want to use this? What's the purpose? What's it doing for the students or staff if it's a provision for them? Why are you doing it? What's the risk if we don't do it? What are we losing out on here? Justify it to me, and then make sure that the DPO has the final say on the matter. They should be saying, okay, here's a risk for you. They're going to say, well, I think that's a very high risk, and then it goes back to in some form of approval process. But if it's being decided, selected and approved by the individual who was bought into the idea, then you're never going to know what your risks are. So as much as possible, and there's lots of stuff going on at the moment, making sure you know exactly who these providers of online lesson provision and education provision, knowing who they are is sort of route one. If we don't know who they are, then we can't really make a judgment call on how compliant they are and how compliant we're being. So the best way to do that is to build a short protocol or just a policy. Everybody who's going to be signing up to any of these services needs to know exactly what the pathway is, who they need to get approval from, and ultimately who in the school is going to give full approval once the DPO has given their advice on it. So building that is just it's a massive part of the puzzle, that once you get it in there, things start to smooth out a little bit. Also, teachers and everyone else will understand that once they engage with someone, and again, sort of spoiler alert, but I'm going to talk about this in a minute or two, there should be policies for usage as well, and how to educate people on using them. So all of that should fall into place, kind of like a flow chart. And I'd recommend that they do that. And again, it's back to identifying the correct lawful basis. It all fits in. Normally, it's provision of education. You just have a good argument about, is that right, and can we use public interest? There may be sensitive data. So we've got to look at Article 9 or Schedule 1 of the DPA. So we have a kind of enhanced level we need to think about. Is it in the public task to be able to do that, to provide this if there's going to be sensitive data transferred? Can we really justify that? What are the risks in that? So I keep harping on about it, but if you don't know these things, you don't centralize it so someone can keep track of it. The rest of it is just fun and games, really. You can't demonstrate accountability.
Perfect. And as you said, the DPO should have the final say, and maybe the DPO also has some suggestions. As I can only say from Germany, the authorities left organizations, companies, schools kind of alone with what tools to use. They just said like, no, you cannot use that, you cannot use that, but they also didn't make any counter suggestions. So I don't know how it is with the ICO. I see the ICO always very helpful. As you mentioned, the template for the DPIA was great. I even use it for German clients, for Spanish clients. So I see that here very helpful.
Yeah, I think the ICO are incredibly helpful, and a good part of that DPIA process might not be something that we can utilize now, but part of the ICO's remit, like all the DPAs, is consultation to help us with these things if we're not sure, if we need assistance. So regardless of your means, if you are there struggling to do, multiple jobs in your one small primary school in the coast, which I know hundreds of, you can rely on the ICO. They are going to be jammed at the moment. There's no lying about it, but they will work hard to work with you, in my experience. There might be people who are tutting now about me saying that, but in my experience, if you go to them proactively, they would always rather that than someone coming at you with a problem. And that's much easier to explain. The good old adage of it's much easier to ask for forgiveness than permission does not apply with data process in any kind of data protection, so especially this.
Very good to know. So as the switch to online and remote education happened really fast, I saw a lot of teachers that use tools that have not especially been created for educational sector. So like meetings and lessons have been held in Zoom, Microsoft Teams, Google Meets, etc. What are the risks here, and what do I need to be looking for, especially when using such a tool?
Yeah, I think the risks fundamentally, if there are risks, is these are not specific tools for the service that you are wanting to provide. That's probably the easiest way to discuss it. They're not designed specifically for schools. It doesn't mean they don't have an application at the moment. That's certainly not what anyone would suggest. But when you look at all of these, again, it's back to risk assessment. What could possibly go wrong? Bearing in mind you have an ongoing obligation of safeguarding to the individuals that are going to be users of this product. So I guess back to our very early slide, do you have to do it? Online classrooms, there's lots of really great eager teachers who want to keep doing that. They want the interaction with their students from home, and sometimes, like we'd say, they want to keep them connected with the children of key workers who are stuck at school at the moment. I say stuck, I'm sure they're loving it. But effectively, if you're using these platforms, are they safe? We know, I'm not going to highlight any one platform. I think they've all got their merits and demerits, but we know there's examples of some of them, maybe their security's not been up to snuff. It's not been to a standard, and some of the hacks, the examples thereof, would certainly fall short of the safeguarding requirement for if you had a classroom of children online. So if you know that's a real risk, and if things haven't been done, I will say that a lot of them started to up their security in response to this, and it's as difficult for them as it is for anyone. But if you know those risks are present, can you really say that you are being accountable in the way that you are deciding what risk, and benefit balance that you are putting your students under, for example? So look at the security level, look at the user controls. How easy is it for people to understand how to manage their privacy? Bearing in mind, a lot of the children or the parents might not be that sophisticated with the use of this. And I say that quietly. I've got a 7-year-old niece who can work any IT much better than me. However, once you bring in things like an uncontrolled environment, so it's not on a standard platform, you have a user risk kind of blow up, which is conduct based, essentially. What kind of information is being provided on screen? Will you be sharing information about individuals? On top of all of that, some teachers, I very much understand it, much like we are with this webinar, they want to record it, so people who don't have access are able to review it at a later date. All of this needs to be fed into your records of processing. You need to build retention periods after this. You need to make sure there's privacy notice updates. So it all comes with some form of obligation that needs to be managed, and that has to be in your thoughts when you're thinking about what do we do. If you haven't done it already and this has been executed, retrospectively start working on it as quick as you can and make a judgment call as to whether it's safe. You cannot do better than, all teachers work to a code of conduct anyway in almost every school as to how they deliver classes, lectures, etc. Exactly the same rules apply for online. I know some schools who go down to the detail of They want you in a shirt and tie and suit, much as you would be. You know, understandably, the kids are probably in pajamas and onesies, and that's their call, unless they've given the kids a code of conduct in that respect. If you're sitting in a webinar, much as we are, you know, limit what's on the background. It's fine to have a map here of London, but potentially, you know, I wouldn't want pictures of my family and everything else on there. That's not my call to make. So I would look at a policy again, a code of conduct that can be delivered to teachers and students about how they are to interact with this. If they are using a specific platform as well, that platform will have security information, how to turn off their cameras, their mics, etc. Make sure they're doing that and they're able to manage their own security. That's really, really important. I think we'll put another note there, which is something that's gone on for a long time, but if they're using a general access platform like YouTube, maybe think about limiting the access to the group who can actually watch the images. Drama teachers understandably like to do that. So, you know, have they got the right to share that information if they're going to be putting kids on there? And if not, just if it's a recorded medium, certainly start thinking about if they're giving out personal information of students and such online. So they would all be things to think about. Probably everyone is sick of the DPO saying it, but most of it you've got to get in the policy. One, it's going to help people understand what they need to do to make that policy simple and, you know, accessible, but also it demonstrates your accountability, which shows that you are doing your best during a difficult time.
Absolutely. I also wanted to mention, especially a policy, just with some guidelines, very basic, as you mentioned, like blur the background, limit the access, and also make it available to the parents as well. I would say, if you are educational service for younger people, as you said, your niece, maybe if she's 7, she cannot understand it so well, so make it accessible really to everyone, send it out before. Very important here.
Absolutely.
So could you also summarize a bit the key considerations we have to especially look at during the lockdown, during this special situation we have here?
Yeah, absolutely. I think top point when you're looking to engage with the vendors is work with them. Having sat on the other side of the table with EdTech, and this is part of our summary point as well, it's massively important for them that they are perceived to be compliant with data protection. Some years back with schools, it was seen as maybe, I'm tempted to say a nuisance, and we would be the guys who are blocking them getting on with their day job. I think schools have come around to that and they've linked it in with the safeguarding and the importance of that. With EdTech, completely the other way around. These vendors, these suppliers, if they are wanting to supply into education, they want to work with you and they should be trying their hardest to demonstrate that they know what they're doing. So that's a massive part. Work with them, ask them how how they can fit into your framework, how they can enable your users, your students, or your teachers if they're working with them, to actually protect their data. That's massive. And if they've got that information, you know you're on the right route. So educate your users from that kind of information. Again, it's guidance, policies. Yeah, that if you're going to implement something now, you've decided that we want to start doing online classes, etc. We want to start implementing this particular app. Get the information out to parents and students beforehand, prepare them, explain to them anything that they need to do, and also how their data will be used. Update the privacy notice and make it very clear where you've updated it as well, then just bury it in text. Obviously, there's going to be a use of data that may not have been there before, so you need to update your records of processing and all of the information that needs to go in there. It might be worth considering. It's certainly something I've talked about with my clients, is a lockdown record of processing activity. If it's something brand new, and equally if it's something you don't know will continue afterwards, there's no harm in separating that out. You can draw from existing ROPAs if it's going to be some of those bits, but stuff that will be specifically highlighted during this period, it might be an idea to do that for admin purposes. And then, like we talk about, the privacy notices are going to be the key area. Just make sure you're doing your legal obligations. Make sure all of those vendors you work with enable you to carry out the data subject rights, and you're not caught short in that respect. You are ultimately always liable for their actions, and there's nothing you can do to get out of that. So they will probably be the key considerations in terms of provision of an online education tool.
Great, thank you so much. That was really, really helpful. Another question, very interesting point. what I get also asked a lot is the publication of images of children on websites and social networks, because with schools we see the pictures of children, the pictures of students. So you need consent, this is for sure. There are basic forms for the use of photos and videos, easy consent forms you can find online. And for children, of course, you need the consent of the parents. And you also need to establish policies here to store the records. And what I think is really important, that you also know what you need to inform about. Of course, you need to inform about, of course, that you publish the pictures, on which social networks you will publish this data, and for what purpose, who can access it, and of course that they also can withdraw the consent at any time. And then you really have to be ready, and also your systems have to be ready to take the picture down.
Yeah, I think
So
that's
anything
perfect.
you want to add in this regard?
No, I think you nailed it. I think at this time, at the moment, schools more than ever want to start publishing pictures of what the kids are up to at home, what they're doing, to try and bring some kind of togetherness at a very disparate time. So it's happening more than ever. Just make sure that you've got the consents and the rights to do that. In all the excitement to get that information up, sometimes things slip through the cracks. So just keep being diligent, but I don't need to tell that to education providers. They are pretty good at understanding the safeguarding requirements. One of the key things is just make sure that those consents line up with the actions that you're performing. So, quite often we see a general consent, I'm happy to have my information published, and then someone will complain about it. So, well, I didn't know you meant on, Instagram. I was unaware that you had a Facebook account. So make sure you're as granular as you possibly can with that consent. And it also means if someone wants to withdraw from one stream of media, they don't have to withdraw from all of them, and the kids can still feel like they're maybe part of the whole kind of sharing of information and what they're up to, but on a more closed network, maybe like a school network, but you don't want it publicized on Facebook or something like that. So that's probably the only thing I would say in addition to that. Make sure the consents you're relying on now, or choose to rely on, link up very tightly with what you want to do.
And also that the consent is for the right purpose, right? If I list, for example, I want to publish the picture on Facebook and Instagram, but then I want to publish it also on LinkedIn, then I need consent also for LinkedIn again.
Yeah, and that's it. Get it granular. Make it as granular as possible. Someone asked me the other day if they could use a consent they had from I think it was Instagram to TikTok, and of course, first of all, we have to all go, what's TikTok, right? Yeah, that's exploded now. But it was just saying that you've asked for a very specific class of consent, and you need to make sure it matches. So you're putting yourself at a risk if you just think that one's very similar to the other.
Absolutely. So Ben, again, to the question, how can we choose a platform that guarantees privacy? What are the most important points to consider here? I think you have a lot of experience in that, and also a lot of customers who ask you the same question.
Yeah, everyone asks for a guarantee of privacy. And I guess what they love to hear us say is, I can't guarantee you privacy, but you can do a lot to work towards it. Like straight at the start, if the DFE are giving you an idea of things that are going to limit the use of personal data, they're a good place to go. But if you feel that you need to go in excess of that usage of personal data, most important for me is think of that kind of triangle of users. There's the school. Does whatever you're using, does it align with your framework, your tech framework, your privacy framework, how the teachers understand if you're using, like I said, simple example is, if you're commonly using Google as your main framework and suddenly you start using a Microsoft product, people might not know exactly how it works. I mean, if my wife uses my Microsoft computer and she's so used to using Apple, I just get shouted at that the computer's not working. So it's understanding that different platforms and different technology might not be aligned to what you're using. It might be a fantastic product and it might be used by the most outstanding educational establishments, but does it fit what you're doing? So that's question number one. Number two, does it align with what your users want and need? Does it fit the purpose that we talked about at the start? But also, do they have the resources and the tools to make sure that that product is safe for them? Does it line up with, I know that there's lots of, there's really good charities at the moment that are offering short-term loans of hardware to kids that can't get access to computers. But are those computers safe? And everything else. We can't control children's hardware. with bring your own device policies to the same extent that we can with other commercial organizations. So is it simple and is it safe in that respect? And then really the point number 2 is, that starting point for me is look at their privacy notice. Before I look at how good a processor someone's going to be, I want to know if they're a good controller. If they're not talking the right language, and I know that lots of people on here will be tutting and say, well, they're just a processor, but if they're not talking the right language as a controller, it's a good indication that maybe they don't understand all of the obligations that flow out of that. So as we talked about before, work with them. They want your business. Talk to them about what they have in terms of assistance with DPIAs. They might have a ready sheet that you can utilize that will line up exactly the tech spec of the product and some of the privacy risks. Look at the information they provide you in terms of a data processing agreement. That needs to be in place between you, and you need to think about, are we compliant with what they're offering? There's lots of commercial terms that can drop out of that. You've got to be happy with those as well, because you always bear liability for that processor. There's a good point there, which is cloud computing services. They'd be put off if they're outside of the EEA, but you need to make sure you rely on a suitable safeguard for transferring that data. More and more we're seeing, certainly with Google, they're moving their data centers outside of the EU. So we need to look at is Privacy Shield or another suitable safeguard in place. Again, that's another wonderful webinar that you can watch, which I think Rob covered in your last one. And then in terms of, I suppose it's kind of what else can the product do to enable you to fulfill your obligations security-wise and data privacy-wise. If you're looking at all of those things, and everyone's gonna, I think if we're playing the drinking game, everyone will be drunk if they drink every time I say DPIA. DPIA would be what you do. You build it in there and say, right, does that suit our framework? Can our users use it safely? How much education needs to be given to both sides of the user interface? Do we have the resources to do that? Are they working with us? Okay, we'll make a risk-based decision. So that's kind of the summary. And I wish I could put it into 3 slogans like the government, but unfortunately, they're the key things you need to think about.
Perfect. Thank you so much. So generally speaking, and we already spoke about this a lot, every educational center needs to have a sufficient data protection program in place, just especially in these times. And we spoke a lot also about risks. So first, you need to detect and identify those risks. Also, again, here we come back to DPIA and speaking a bit also about PridaTech and what PridaTech does. PridaTech helps you to detect and identify those risks, and later on also to define and suggest measures, because of course you need to mitigate those risks in order to make them bearable for the data subjects. And then we speak about this a lot. Data security, data protection is not a one-time thing. It's not you do it and then you're done with it, but you need to review it constantly. And this is also what the program helps you a lot with. So we have the solution. We developed a solution, a tool for this. You can do risk assessments. You can even do the impact assessments, even based a bit on the ICO template we spoke about. And you have privacy reports. Also very important, all those guidelines you need. Guidelines for using tools, for using those e-privacy learning platforms. Then also a good privacy policy everybody needs to check upon. And of course you can test this. You have a free trial at PridaTech. You can use it 7 days for free. You just need to contact us in that sense, and yeah, just try it out. And now we get back a little bit to the questions you asked during the webinar. Just let me check them quickly because the system is a bit strange. So yeah, first question we always get asked is, do you record the webinar? Of course, we send it out later to everyone, so no worries for that. Then next question, and you will smile about that, I think it was a bit asked before you said the last part, how do I guarantee that e-learning is safe, that is GDPR compliant? So I think you covered that part pretty well. Do you want to add or anything to that question again?
No, I hope so. If anyone's got any alcohol left in their glass, DPIA, so you can finish that off. But it's knowing the risks, look at the mitigations. I wish there was a one-size-fits-all cure. There isn't. All those things I just talked about on the previous slide there, though, just look at if it fits into your framework. Are they working with you? All those kind of things should be really key for me. If you've been in data protection for a while as well, you get a bit of a sense of who knows what they're doing and who might be kind of fudging it a little bit for you so they get your business. So they would be the kind of, not that you should go with your gut, must be important, you know, put it into the risk assessment and look at if they're working with you.
Yeah. Then we have another question. When working from home, is the data controller the school or the teacher? I would go back here to another webinar we had just in respect of working from home, working remote. It's always the employer. The employer is always in charge of data protection here, not the employee. Also here, it's always the educational center, which must already have established, as we mentioned before as well, like guidelines, policies for the teachers, so they are trained in this aspect, right?
Mm-hmm. Yeah, absolutely. I think that's the case. There's very, very small minimums in terms of, I would say there's an exclusion, say, consultants that might work for the schools full time in some, certainly in private sectors. That might be separate controller position. But other than that, absolutely, the school or the governing body is the data controller, and they're responsible for making sure those policies and security protocols are in place.
And I'm sure, like in the employment contracts, you have like some sort of confidentiality agreement, confidentiality declaration there, I suppose.
Yeah, absolutely. That should be there as a minimum with all jobs anyway. That's an employment law part of things, but there should also be data protection clauses so people understand how that fits in, if not in the contract, but certainly in their employee handbooks or a separate policy regarding data protection. That should all be there. Certainly everyone in the organisation should be conversant in that.
Okay, then we have in this webinar, that's good. On the last one we had no questions, here we have a lot. For processing the data of minors, is the consent of both parents required, or is it only is one parent sufficient? What happens in the case of a disagreement?
Yeah, that's a sticky question. I think, effectively think about who do you need to be asking consent from? What's the consent for? If we're talking about use of information society services, like we touched on very briefly before, for kids to link up and such, in the UK, they can provide their own consent after the age of 13. So that's one sort of way to look at it. It's very difficult to look at what age kids can provide or children provide their own consent. The NSPCC provides some really good guidance on safeguarding and also consent requests for image use and other processing of personal data. Their recommendation, which most of the schools I've worked with tend to take on board and very importantly put in a policy regarding this, would be 16 and below. You're looking at the parents to provide that consent. After that, are the children capable of doing it at 17 to 18? Do they have the requisite competency to provide that? If not, and you have to go to the parents, normally a legal guardian can provide that. If there's a disagreement, first place to look at, and this really goes into the family law side of things that all schools get terrified about. If there's a disagreement, is one of the parents the legal guardian? If not, if there's both, you need to put it into a system and look at what's actually best for the child in that respect. I believe these kind of things can end up in court. They can be very contentious. So have a policy that should cover this kind of scenario. What would be the standard position? How would you work out what's best for the child, certainly from a safeguarding position? Really importantly, actually, aside from this, is just because the parent may give consent, the child should still be asked if they're happy for their image to be used. And as always, normal rules apply. If you're taking photos on any day, get your privacy notices, make sure people know exactly what these will be used for. And if the children want to object and they don't want to be part of that, then that's absolutely their right. So, aside from just asking for consent, make sure that the child is happy with that as well.
Okay, great. Then a very important question, I think, is can an educational institution appoint a DPO from among its employees, or does it have to be an external professional? Yes, we had also a little discussion about this beforehand, and I will say the DPO can be internal, but external, I would completely recommend, especially in the sector of education, an external DPO, external professional, as it's just a very delicate sector. And also an external is a specialist, has more expertise, can work more independent than a school employee. And also we spoke before about you maybe have a conflict of interest even. Who can be the DPO? You had a nice saying there, I think.
Yeah, I think they're the two key points. So the answer to the question effectively is yes, you can appoint someone from your existing staff, absolutely. Under the legislation, though, there's some key parts that might prevent that appointment. We need to look at, do they have the requisite experience, knowledge, most importantly, the skill to undertake the job? Do they know sufficient amounts about data protection regulations that will apply to processing of their information? If they can't say that, then that's going to probably put them in a difficult position, and certainly maybe a breach of the GDPR. Also, we have to operate without any form of conflict of interest. This is a great topic that people certainly in the data protection world love to get into, about what constitutes a conflict of interest. And I'm always very nervous about it when there's comments that are available that someone might pitch in and tell me I'm wrong. But can you choose a framework? Can you look to implement it and mark it at the same time? So in terms of IT is one of the common ones where it can happen. There can be a distinction between the two, but ultimately, if you're picking something from a security side of things or a data protection side of things and marking your own homework, it can be very difficult to demonstrate that.
That was the thing I was looking for.
Sorry. Yes.
That was the thing I was looking for. That was a great comparison.
Yeah, you've teased it out of me, expert presenting there. But that's it. Are you marking your own homework? Can you be independent? If the answer to either question 1 or 2 is not really, we don't know enough about what we're doing, or we can't really be independent. Also, you cannot relieve someone of their position. You can't sack them because of something they do as a data protection officer. So if they're holding dual roles in the organization, and they might not be particularly good at role number 1, say they're in accounts or something else, and you sack them, then potentially you've got lots of liability if they accuse you of sacking them for some advice that they gave as a DPO. So there's a whole untested area of law there I'm sure we'll see develop. But the general answer is yes, absolutely, but with those caveats. You must have sufficient knowledge to carry out the role, and you cannot let your existing role conflict with the provision of services DPO.
Great. So we have a lot of more questions. The rest of them we will answer after I say one last question, because it's already almost time is up. Do I have to sign DPAs with the tools used on an ad hoc basis right now? So
okay.
As we said, DPAs are great, good to sign, but in most of the cases, it won't be possible right now. So my recommendation here would be also having a closer look, as you said also before, to the privacy policy, to check that out, and then later on to get into the DPAs. What do you say?
Yeah, I think there's two answers to that question, and I think I always tinge the fact that we're not in a normal scenario at the moment, and everything we've talked about today, and I probably want to talk specifically to the people who have just done their best in a difficult situation and used tools that they've maybe not used before because they're trying to do the best for their students at the moment. So that's where I'm kind of pitching it. And the general legal position is we need to have written terms that are compliant with Article 28 of the GDPR in place with us and the vendors. You may find more often than not, actually, if they know what they're doing and they know they're processing personal data, those terms are actually there. They're incorporated into their commercial terms. You've already signed them. We're always asked when someone's using a data center like Azure, oh, have I signed a DPA? And I say, well, if you've clicked the I agree to their terms, then I assure you it's in there. They tend to say, oh, do we not need to start DPA? And I was thinking, great, have a crack, send it to Microsoft, see what they come back with. I'm sure they'll be really keen to negotiate terms with you. However, in reality, that doesn't happen. So yeah, privacy notice is the first place to go. How are they using data? There's got to be security assurances. These should be red flags if they're not there, or if there's any concerns about the privacy notice. My feeling is they should always have DPAs available. They're a data processing body. They might just be download, our DPA. You see that quite often, and that might be all you have to deal with, to be perfectly honest. That might be all you get at this time. And again, people are sick of hearing me say it, but it's a risk there that you need to load into that impact assessment if you don't have one present. What's the risk of not having one there, organizational wise, and for the data subject? So think about that. And as things return to normal, we're looking at a proportionate approach. And I know I'm ticking on past 4 o'clock. I think it's worth just touching on the fact the ICO said that moving forward, they are going to, during this pandemic, they are trying to take, I believe the term is proportionate and empathetic approach to enforcement and their other duties. I think that's really important. We should all think about that. What's proportionate, you know, in terms of what we're doing? There's a high risk there. If you really only have contractual controls to rely upon, then you really are going to need to get them sorted. Then look at the risk balance otherwise. But, you know, my advice is get them in place as soon as you can. But the reality is, I understand that might not happen. So another great answer. I do apologize. It's not simple and straightforward, but they're not really simple and straightforward times.
Absolutely. In these times, you cannot just give black and white answers, unfortunately. So thank you very much, Ben. Thank you for your attendance, for your advice, for your help. It was very interesting, very insightful. And yeah, maybe we can repeat that soon. Thank you very much.
Absolute pleasure.